it's de novo at the contest stage. What possible advantage is there to go through the protest proceeding?
If you've identified the ballots, you could presumably wait and do it at the contest phase. There's no particular advantage to doing that. The fact
I thought the advantage might be, as described in the Florida case, Boardman versus Esteva, saying that the certified election returns, which occur after the protest period, are presumptively correct, and they must be upheld unless clearly outside legal requirements. I thought that was Florida law.
Your Honor,
which would make it important to have a protest.
I think that's right. I think that is right. I would point out that
I think the Florida court has sort of ignored that old Boardman case.
Your Honor, I think the Boardman case relates not to the counting of votes. It has nothing to do with the standard in terms of the intent of the voter. The Boardman case, the language that you're referring to, is at page 268 of the Southern Reporter report of that case. And what is clear from that page and that discussion is it's dealing with the issue of whether or not, because the canvassing board threw away the envelopes from the absentee ballot so they could not be checked, whether that invalidated the absentee ballots. And the court says, no, it doesn't, because it's important to count all these votes, and because we assume that what they were doing was proper. That does not, I respectfully suggest, at all deal with the question of deference to the voter intent determination, which the court has repeatedly said is a matter for judicial determination. And the other thing that I would say with respect to intent is I know the court is concerned about whether the standard is too general or not. Some states have made specific criteria their law. Other states, not just Florida, 10 or 11 of them, including Massachusetts and the Delahunt case that we cited, have stuck with this very general standard.
All right,
There's a sense in which that may be an Article II issue.
Mr. Boies, let's assume that at the end of the day, the Leon County, Florida judge gets a series of counts from different counties, and those counties have used different standards in making their counts. At that point, in your judgment, is it a violation of the Constitution for the Leon County judge to say, I don't care that there are different standards, as long as they purported to follow intent of the voter, that's good enough?
I'll extend your time by 2 minutes, Mr. Boies.
Yes, I do not believe that that would violate the Equal Protection Due Process Clause. That distinction between how they interpret the intent of the voter standard is going to have a lot less effect on how votes are treated than the mere difference in the types of machines that are used.
Then the fact that there is a single judge at the end of the process, on your judgment, really is not an answer to the concern that we have raised.
No, I think it is an answer. I think there are two answers to it. First, I think that the answer that they did it differently, different people interpreting the general standard differently, would not raise a problem, even in the absence of judicial review of that. Second, even if that would have raised a constitutional problem, I think the judicial review that provides the standardization would solve that problem. The third thing that I was saying is that any differences as to how this standard is interpreted have a lot less significance in terms of what votes are counted or not counted than simply the differences in machines that exist throughout the counties of Florida. There are 5 times as many undervotes in punch card ballot counties than in optical ballot counties. Now, for whatever that reason is, whether it's voter error or machine problems, that statistic, makes clear that there's some difference in how votes are being treated county by county. That difference is much greater than the difference in how many votes are recovered in Palm Beach or Broward or Volusia or Miami-Dade. So that the differences of interpretation of the standard, the general standard, are resulting in far fewer differences among counties than simply the differences in the machines that they have.
Thank you.
Thank you very much.
Mr. Olson, you have 5 minutes remaining.
Thank you, Mr. Chief Justice. I would like to start with a point or two with respect to the equal protection due process component of this case. The Florida Democratic Party on November 20 was asking November 20th of this year was asking the Florida Supreme Court to establish uniform standards with respect to the looking at and evaluating these ballots, a recognition that there were no uniform standards and that there ought to be. Last Tuesday in the 11th Circuit, unless I misheard him, the attorney for the Attorney General of Florida said that the standards for evaluating these ballots are evolving. There is no question, based upon this record, that there are different standards from county to county.
When there are different ballots from county to county, too, Mr. Olson, and that's part of the argument that I don't understand. There are machines, there's the optical scanning, and then there are a whole variety of ballots. There's the butterfly ballot that we've heard about and other kinds of postcard ballots. How can you have one standard when there are so many varieties of ballots?
Certainly the standard should be that similarly situated voters and similarly situated ballots ought to be evaluated by comparable standards.
And you'd have to have several standards.
Well,
county by county.
You're certainly going to have to look at a ballot that you mark in one way different than these punch card ballots. Our point is, with respect to the punch card ballots, is that there are different standards for evaluating those ballots from county to county, and it is a documented history in this case that there have been different standards between November 7th and the present with respect to how those punch card ballots are evaluated. Palm Springs is the best example. They started with a clear rule which had been articulated and explained to the voters, by the way, as of 1990. Then they got into the process of evaluating these ballots and changed the standard from moment to moment during the first day, and again they evolved from the standard that the Chad had to be punched through to the so-called dimpled ballot standard, indentations on the ballot. There was a reason why that was done. Because they weren't producing enough additional votes, so that there's pressure on to change the standards. And that will happen in a situation where the process is ultimately subjective, completely up to the discretion of the official, and there's no requirement of any uniformity. Now, we now have something that's worse than that. We have standards that are different throughout 64 different counties. We've got only undercounts being considered, where an indentation on a ballot will now be counted as a vote, but other ballots that may have indentations aren't going to be counted at all. The overvotes are in a different category, and in this very remedy, the ballots in Miami-Dade are being treated differently. Some of them have been all examined, and the balance of the process, the remaining 80%, will be looked at only in connection with the undercounts.
Mr. Olson, do I understand that your argument on the equal protection branch would render academic what was your main argument that's troublesome, that is, that we must say the Florida Supreme Court was so misguided in its application of its own law that we reject that and we, the Supreme Court of the United States, decide what the Florida law is?
I'm not sure I know the answer to that question, and whether that would render academic the challenge. There is a clear constitutional violation in our opinion with respect to Article 2, because virtually every aspect of Florida's election code has been changed as a result of these two decisions.
But the Florida Supreme Court told us that it hasn't been changed, and just looking at one of the cases that you cite frequently, the O'Brien against Skinner case, this court said, well, maybe we would have decided the New York law differently, but the highest court of the state has concluded otherwise. It is not our function to construe a state statute contrary to the construction given it by the highest court of a state.
The only thing that I can say in response to that is that what this court said 1 week ago today, that as a general rule, the court defers to a state court's interpretation of a state statute, but not where the legislature is acting under authority granted to it by the Constitution of the United States. The final point I would like to make is with respect to Section 5. It is quite clear that the court in both the earlier decision and in the decision last Friday was aware and concerned about compliance with Section 5. It construed Section 5 in a way that allowed it, by labeling what it was doing as interpretation, to change in dramatic respects the Florida election law And we submit, because it did so, misconstrued the applicability not only with respect to finality, but the other part of Section 5 requires a determination of controversies pursuant to a set of laws that are in place at the time of the election.
If you start with the premise, a clear intent of a vote should count, where there's a clear intent on the ballot, it should count as a vote, can't you reasonably get to the majority's conclusion?
I don't believe so, because we know different standards were being applied to get to that point, and they were having different results.
Thank you, Mr. Olson. The case is submitted.
The Honorable Court is now adjourned until Monday, the 8th of January at 10 o'clock.
And there you have it. The case of Bush versus Gore has been submitted to the U.S. Supreme Court. How long now until a ruling is just about anyone's guess. The only thing for certain is the conversation immediately following those oral arguments in the conference room behind the bench involving the 9 justices and only the
county boards the ability to conduct a manual recount so long as they do it in a timely manner.
And what happens if it's not there in 7 days?
Well, here
they stop?
No, what we have here, which is they do have certified returns on file. And obviously, if they can't finish the job, then those are the returns that declare the winner.
What do they do with the recount? Does it stop?
I would think that would certainly make sense, but I don't think the legislature contemplated that eventuality, because I don't think the legislature ever contemplated people continuing to count past the time that the votes were tallied.
If it stops, then it cannot be part of a contest then, correct?
Oh, well, what I meant by a contest is what they would do is...
Under 168?
Yes, exactly.
So it cannot be. If it stops, how can it still be part of a contest? That's what I don't understand.
Oh, no, I'm sorry. I think your proof in a 168 would not be, again, on these chads and all of that. I think you would point out, which they claim they can do, that the machines have improperly counted.
But you wouldn't have the recount to prove that, correct?
Well, obviously, if the margin of error of the machines is so bad that they can't accurately predict the winner, then you would be able to show under the 168 procedure that the margin of error is such that it wouldn't affect it could affect the outcome of the election.
But you would not have the recount, correct?
Oh, I don't know, but I don't think there would be any problem in producing, just so I'm quite clear, Mr. Justice, that producing that kind of evidence in a election contest procedure. You could go through, I mean, as I understand it, we're almost through in Broward and these other places, and instead of having every court in Florida resolving on an ad hoc basis the kinds of ballots that are valid and not valid, you would be centralizing that factual inquiry in one court in Leon County. So you would bring some orderliness to the process, and they would be able to resolve that evidentiary question. One way or another, a court's going to have to resolve it.
Let me ask you really simply.
Yeah.
On a machine-counted ballot, where someone has gone to the polls and they have punched the hole properly, but for whatever reason, the chad didn't fall out. Are you saying, under your analysis of this, that, and even if this happened to half of the ballots in the county, that there is nothing that can be done?
No, obviously, if there was a machine malfunction, that...
No, I'm not saying there is a machine malfunction. I am simply saying that the person punched the hole, whatever hole they wanted to punch, but for whatever reason, the chad did not fall out. What would we do with all of those ballots?
I think we'd have to know whether or not the hole didn't fall out because the person punched and the machine malfunctioned, it didn't go out, or whether the person intended to punch where the hole was. And that's...
It's not a machine malfunction, is it, when you punch the
my only point is, Your Honor, you don't have the voter in front of you. You have the ballot in front of you. And what you need to do is what's been going on is look at the ballot pursuant to some objective criteria and determine whether or not the punch, if you will, is sufficiently strong showing that the voter intended to do that to figure out whether or not they intended it. But as we know, and as the colloquy before indicates, that is a standardless and subjective inquiry, which there are no Florida rules on, and that is why they are asking you for some guidance. My point is, how can this court, after the election has been held, start deciding, resetting the statutory deadlines, reanalyzing the statutory terms for resolving empirical questions of the sort that you're discussing, and redoing everything that reflects and considered judgment that's already in the election code?
But that still sounds like you're coming back to all of these ballots would just be not counted. All of those voters would be disenfranchised.
No, I want to make it quite clear. If they did a timely manual recount, all of those ballots would be included in. Now, let's assume that they were not. Let's assume that they were not. Then they would be in precisely the same position as all the other voters in Florida, but I don't think the people in those 63 counties were disenfranchised because the legislature did not believe that manual recounts were the only proper way of discerning the voters' intent. And for the court to disagree with that would require this court to substitute
What other way would you determine the voters' intent? If it's not picked up by the machine and you don't do it manually, how do you determine?
Well, the question is accurately assessing the number of votes. And you only get to the question of the voter's intent either in a contest election or in the protest election under 166. And I would think you would do it presumably in the same way in both contests. My only point is there are no standards established by federal law, which is why we have ad hoc switching back and forth. And I would urge that the court not, after the election has been held, change the rules by which the election should be conducted.
Mr. Garvin, I think you should let Mr. Richards have his time if he's going to use it.
If I may just wait one final point. He also represents Mr. Bush, and I just did want to bring the court's attention very quickly, if I could, to 3 U.S.C. Section 7, which makes it clear that the federal law allow this court or the Florida legislature to change the rules of the election after the election has taken place to avoid precisely the evil I have been discussing, which is that there will be ad hoc decision-making that could be influenced by subjective or partisan concerns.
Thank you, Mr. Garvin. Does Governor Bush have 5 more minutes for Mr. Richards? Okay. Thank you, sir.
May it please the court. When all is said and done, when the questions posed by this court have been asked and answered, we come down to a single final issue, which is this. What the appellants are asking this court to do, and in fact what the court must do in order to arrive at the conclusion that they seek, is read a statute that says that returns must be filed by a date and time certain as though it said may be filed, to read a statute that says that the Secretary of State may accept late filed returns as though it says must accept late filed returns, to disregard a statute that says that the Secretary of State's opinion as to election matters is binding upon all those officers and agents within the election system, and to disregard the well-established and long-standing doctrines regarding clearly erroneous standard and implied repeal. And finally,
would you address the question that was posed before, that if we stop, or if you have the 7-day cutoff, do recounts stop at that point, or do recounts continue to be used as part of the contest?
Well, I think the recounts must stop if the 7-day cutoff occurs unless the Secretary of State, in the exercise of the discretion that the Florida legislature has given her, determines that there is rational reason for them to continue. It is the job of the Secretary of State. It has been reposed in her by the legislature, and 2 constitutions, the United States Constitution and the Florida Constitution, in unusually explicit language, have delegated that decision not to the state of Florida, not to the courts of the state of Florida, but to the legislature of the state of Florida. And the legislature of the state of Florida has reposed that authority in the Secretary of State. Now, in order for us to do anything else, this court would have to disregard the most fundamental principles of separation of powers and do what these appellants are asking, to step into the shoes of both the legislative and the executive branches, to rewrite these statutes and to begin the process, which I suggest to this court is never ending, of sitting as a determiner, of an ultimate arbiter of the minutia of facts that go into the election process.
Mr. Justice Quince, you.
Yes. Would you agree that the parties, the party, meaning the political party, and the candidates have a right to request a manual recount, correct?
They have a right to request it, although, interestingly, their request has no meaning under the statutes. It's entirely within the arbitrary discretion of the canvassing board.
All right, and assuming that the canvass board says, yes, we will do this, how do you square that statute with the 7 days? If, in fact, suppose it's asked the very day after the election, yet for whatever reason, it cannot be completed by the 7th day. How do you read these two statutes together? How do you make sense of it?
Somebody, whatever the date may be, whatever it may be, there's going to be a date. It's to the legislature to decide what that date is, and if somebody fails to reach it, some agency of the state of Florida must decide whether or not there was a rational, acceptable reason for failing to do so. The Florida legislature, which 2 constitutions have given that power to, has decreed that the agency that shall do it is the Secretary of State, not the courts.
And what are the guidelines for the exercise of what you see as that discretion?
Well, the legislature has established no guidelines. The guideline that this court has established, as long as institutional memory exists, is whether or not the exercise by that state agent is clearly erroneous. And I suggest to this court that the appellants have given this court no basis in this case for finding that the Secretary of State's decision was clearly erroneous. That's the issue. And whether or not history ultimately looks kindly upon what we do here, I believe, will depend upon whether we have abandoned those principles of law and statutory construction and separation of powers that we have adhered to for so long.
Does the statutory scheme contemplate that there be initial returns first filed within a certain period of time?
Well, the statutory scheme contemplates that there will be only 2 things. One set of returns filed 7 days by 5 o'clock, 7 days after the election, and a second set of returns mandated only because the federal law takes precedence over the states, and because only to the extent that there's a conflict, the state must therefore comply with it. The suggestion by the appellants—
But the Secretary of State cannot certify official results until she receives the absentee ballots, and the official results also include manually counted ballots. Don't we also have to look at those portions of the statute and read them to come up with a logical whole in this case?
Justice Parenti, I would suggest that that is not the statutory scheme that the legislature has given us. The suggestion by appellants that there can be continuous certifications and supplemental certifications is not what the statute says. If you read the statute, it says there is one certification mandated by 5 p.m. 7 days after the election, and that's the only one. The only reason there's a second one for overseas absentee ballots is because the federal Congress has stepped in, as they have the right to do, and has said that the states must allow that, but only to that extent.
Mr. Richards, your time is up.
Thank you
very much. And on behalf of Mr. Butler, Mr. Mardenborough.
Mr. Chief Justice, may it please the court. Your Honors, I'm here representing a voter, and I'd like to spend the next few minutes talking about what this entire process has really meant, not from the voters in South Florida's perspective, but what it really means to the voters in the other 63 counties in the state of Florida. And the first thing that I'd like to clear up is, Justice Parienta, you asked a question before that said something like, could the voters have asked for a recount? And they couldn't. There is no right under Florida statute that would allow the voters to ever ask for a recount under these circumstances. Now, unfortunately, we've spent the last hour and a half to 2 hours, and certainly the last few weeks, listening to everybody trumpet the rights of the voters. But the rights of the voters aren't what this is about. This is about the crafty use of a statutory scheme in an attempt to skew election results. And that's just not appropriate. The legislature set up a statutory scheme that puts two different levels of challenges to election returns. That's been talked about now for a while. The first part is the protest period. The protest period is a separate and distinct thing from the contest.
The protest can be asked for by any elector qualified to vote in the election.
That's absolutely true, but that's not true when it comes down to the manual recount provision. If you look at subsection 4 of section 102-166, that provides only that a candidate, a political, well, in fact, when it's a person being voted for, it's just a candidate or a political party that can ask for a manual recount. A voter cannot ask for a manual recount.
But they have a right to protest.
Well, they can do the other portions of the protest provisions, but those do not include a manual recount right.
Well, that's what since that section 1 was here before section 3 and 4, and since there were manual recounts in the state of Florida before 1989, we must assume that the right to protest carried with it a right if the court decided to have a manual recount.
Well, if a court decided to have a manual recount, that may be true, but there's certainly not a right for a person, a voter, to go in and ask for a manual recount. Just as you pointed out, subsection 4 was added later, but the legislature specifically restricted who could ask for it, under the normal principle that when the legislature identifies certain parties that can do something and they omit other parties,
but here
they appear to mean it.
The canvassing board has authorized it, has it not?
Where?
Hasn't it authorized the manual recount?
It is authorized manual recount.
That request period.
I'm sorry?
We have passed the request period. The canvassing board has authorized the manual recount. Is it?
That's true in the counties that we're talking about, but there was a request made in all of those counties by one of the statutorily permitted people within the 72 hours. Although some of these counties have just now made the decision, they were asked to do this 2 weeks ago or 10 days ago. But the problem here is the voters in the rest of the state of Florida couldn't do that. And we believe that that's probably not constitutional. We believe that it violates the equal protection rights of all of the people in the other counties in the state of Florida, because their right, to the extent that it is provided by a statute, to have their ballots looked at to see whether they made a complete punch through their punch card, is dependent solely on where they live and whether or not they're lucky enough to have a candidate or a political party ask to have somebody look at their cards. Now, I understand that Governor Bush may have had good reasons, and he may not trust the process and may not like the manual recounts. However, his decisions shouldn't affect the rights of the voters. Again, I think it was said earlier, the real parties in interest here are the voters. But they can't even ask for it.
Position that the right to have a manual recount should be open for any county where that decision is made by the county canvassing board?
I'm not sure if I understand your question.
You're saying now that the way that you're saying you're raising a constitutional attack on the fact that voters do not have the right to request a manual recount. So is the remedy then the remedy you're seeking? And you sought it within this.
Well, and I need to be completely candid here. Because we were an intervener, that wasn't specifically asked for in this case. That has been addressed in Leon County Circuit last Friday, and that decision of Judge Clark has been appealed. I'm not asking you to rule on the constitutional issue. What I'm pointing out, though, is that the scheme as it exists is unfair, and one of the things that it really comes down to is if you look at the difference between a protest and a contest, you can find some fairness to take care of that. And here's why. If there's a protest, somebody goes to the local canvassing board and says, we want to pick in our little area, we think we can change the votes in this little part of the state. We think that in Palm Beach County we can change the votes. But that doesn't take into account that there may be a lot of changes that would happen if you did it through the rest of the state. It's a completely local decision that has statewide ramifications. The legislature, in its wisdom, said these protests are going to have to be done, at least the results are going to have to be done within 7 days. They said that the results have to be certified within 7 days. Now, we happen to take a different position on whether or not those manual recounts could go on. It may be that the legislature intended that manual recounts can keep going, but they're of no use in the certification process. They may become evidence at some point in a contest. The difference, and this is a fundamental and a critical difference in this case, is that when somebody is contesting the election, as it's been discussed before, they would be doing it in a Leon County Circuit Court because the statutes recognize that if an election is going to deal with or affect more than one county, it shouldn't be local, it's going to come up here. And a judge here is going to have to make that ultimate decision under the case law that's been set forth by this court as to whether or not the results would change whether any ultimate findings would change the results of the election. That would mean that a judge wouldn't only be looking at did you end up getting a few more votes in a few select counties chosen by a political party, but it would also take into account a consideration as to, well, what if that same standard had been applied through the rest of the state? If we got some more votes by checking punch cards in the heavily Democratic parties, what would have happened if the same thing had happened in the other counties? And that's a factor that a judge could take in a contest, an election contest. And that's exactly why we believe that the Florida legislature provided for both a protest provision and a contest provision. If this court were to take the protest provision the way that it's being suggested by the appellants, there's never any need for a contest. There would be absolutely no purpose in the Florida legislature having a section of Florida statutes that defines how an election contest works, because they're saying everything gets done before you even certify it. They're saying the Secretary of State has to sit back and cannot certify the winner until everybody's disagreements have already been resolved. The problem is there is no arbiter to make a decision about the disagreements. There is nobody who makes the factual decisions there. It's just local canvassing boards making decisions based on choices of candidates, whether or not to look at ballots again. There's nobody who's actually looking to see whether overall this is going to change the results of an election.
But why isn't it really what they're saying is that you don't have a contest, an election contest, until you have had the procedure that concerns a protest? Because there certainly you can go through this protest procedure and still get to the contest procedure.
Certainly. However, the legislature wrote both of those provisions. The legislature said there's going to be a protest provision, but the legislature also wrote that there is a 7-day deadline for getting the certifications in. And for this court to, the first step this court has to take in interpreting that statute is, can you read that whole thing together? Can you look at Chapter 102 and can you read it in a way that all of the provisions actually make sense so you don't have to just ignore one of them? Because you're being asked to ignore the 7-day rule. You can read that entire statute together in a way that makes perfect sense by simply recognizing that the protest period, which conceivably could even be asked for after certification takes place, because they've got 72 hours from the time that the results are certified. So if somebody certifies the results on...
The provision was 72 hours or 5 days or before the votes are certified. It seems to me that provision doesn't allow for the protest once the votes are certified.
I'm sorry, I don't have the specific...
Those time standards are in the alternative with the later date prevailing, are they not?
Right, yes.
So you either have the 72 hours or the time of certification.
Right. I think that it's certainly conceivable, and in fact, I think the only reasonable assumption is that the legislature knew that sometimes there were going to be protests that were going to be going on, and that the legislature recognized that sometimes there were going to be manual recounts that were going on, and it still chose to leave the 7-day deadline in there. They didn't eliminate the 7-day deadline, and when they... I see my time is up.
Thank you, Mr. Martinborough. Mr. Hancock, as I indicated, I think you have 3.5 minutes, and I would pose this question to you, and I'd like Mr. Boyce to also respond to it, that in Section 5 of Title 3, they specifically refer to contest, in that it's for its final determination of any controversy or contest concerning the appointment of electors of such state. Now, under our statute, which is 168, those contests cannot begin, as your opponents say, until such time as the ballots are certified under its express language. Now, why isn't it correct that we are jeopardizing with each passing day Florida being able to have its votes counted in the Electoral College if we don't allow the certification?
Because the 168 provisions do not relieve county officials of certifying election results correctly in the first instance. We know here from Palm Beach County's situation, as Justice Quince points out, that people have cast ballots that under the laws of this state, the opinions of this court, are valid votes. They have not yet been counted. Once that final count is done, then the procedure for contests kicks in. That is a completely different procedure. That places a burden on a plaintiff to prove that the election results are wrong. Again, however, in the first instance, that burden is on the county election officials to certify a correct result. If I may correct, Justice Sanstead, Professor Rogow has asked me to correct a statement he made to you. In fact, the Palm Beach County Canvassing Commission did request the Attorney General to issue the legal advisory opinion that was issued on the 14th.
Mr. Hancock, Chief Justice has asked a question, and I don't know whether you want to use your time to rebut your co-counsel or not, but where do we find from this record the limits that we are to set in making a determination that we've been asked to say the votes have to be in by a certain time so that the contest provisions can kick in? Where do we find from what has been filed before us the wisdom to do that?
Justice Shaw suggested giving that authority to the Secretary of State. We would suggest, if the court considers that, the court set standards. The standard should be that the counties are entitled, and the paramount interest in doing this is to recognize voter intent. The counties should be given all reasonable opportunities to complete the process consistent with the time obligations in a manner that recognizes voter intent.
Is it the position of the Attorney General that, although we don't have Miami as a part of this case, it's been mentioned several times, that they have just not decided to start their manual recount until today? Would that fall within a reasonable limitation to say this is just too late to do that?
I'm not, Your Honor, I'm not sure of all the facts in Miami. My understanding was that they requested, there was a request, they decided not to do it and then reconsidered that request. I'm not sure. Obviously, the request has to be timely to be considered.
And under the circumstances of this case, do you have an opinion as to whether that would be timely?
I don't have an opinion. I would say one other point, if I could. Justice Periani expressed concern about the dilution of votes with recounts. Obviously, no one's vote is diluted in a legal sense by counting other valid votes. We are concerned, as you are, about other counties that don't have this process. One remedy that the court might consider is having a recount statewide. The problem, as you correctly point out, is on counties using machine-readable punch cards. It would be appropriate, perhaps, to review those punch cards in those instances where a vote for president or vice president was not recorded to determine whether the intent of the voter could be ascertained. That would not be a major burden on any county of the state, and those counties with optical scanners would probably find that the ballots were being read properly.
Could you comment on the federal statute that was referred to as to whether this court, in fact, does have the authority, or are we treading into the separation of powers by making such a determination in this case?
No, this court clearly has the power. In the Harkey versus Raudabush case in the United States Supreme Court, which was a United States Senate election, clearly said that that was a matter that was left to the discretion of the state pursuant to the same article of the Constitution that's at issue here.
Thank you, Mr. Hancock. And Mr. Boyce.
Your Honor, let me make two preliminary points. One, I want the court to understand what the nature of the other side's argument is. They say that what they want to do is have a contest. But what they have said, and what they have said also even to this court, although maybe not as directly as they might, is their view is once the results are certified, then the recount becomes superfluous and ought to stop. And second, that as soon as the results are certified, the Secretary of State can, under 103.011, declare who the electors are. And it is their view that when that declaration of the electors has been declared, it's over with. So one thing that I would urge the court is that when there is a deadline so that the contest can start, that the court stay the declaration under 103.011 so that we're not faced with an argument that says it's all over and the contest has become irrelevant.
But you would have to agree that at some point in time between now and December the 12th or 11th or whenever it is, that Florida's votes are going to be in jeopardy.
Your Honor, I think they need not be for the following reason. We don't believe that Section 111 or 112 of Chapter 102 says there is one and only one certification. That's what they argued, but you won't find that anywhere in the statute. In fact, in 102.111, what you find is a discussion of returns, the returns, and then the official returns. And the official returns, as we've said before, is defined in 101.5614 subsection 8 as being returns that include not only the initial returns, but the absentee ballots and the manually counted ballots. There is nothing, in our view of the statute, that precludes them from making a contest under 168 of the certification that has already been filed with respect to the votes other than the manually recounted votes.
The statute says it's the last certification, the last county canvassing board certification. That's what 168 says.
Yes, and the last county certification for every county except these three. And they were talking about the overseas ballots, and they were talking about other things they said they wanted to contest. Except for the three counties, the last county certification in those counties has already been made. And each of these three counties have also made the initial certification on 5 p.m. last Tuesday. We think that there's nothing in the statutory provisions that prevents a contest with respect to what's already been certified from going forward while the supplemental returns from the manually recounted ballots are also going forward.
But there's no way, for presuming that it's Governor Bush that would have the right to contest the manual recounts that are being conducted in at least 2 out of the 3 counties, for there to be a record in order to contest that, those have to be completed.
Absolutely right, Your Honor. And in order to allow him to contest the manually recounted ballots, you must have a deadline for that, too. My only point was...
But now we go back to this. Deadline is not in the statute. How do we have the authority to set a deadline?
Because what this court, I would respectfully suggest, has to do is to reconcile the entire statutory scheme. And the statutory scheme, long before there was this election, provided for manual recounts. And this court, I suggest, cannot presume that the legislature meant to provide for these manual recounts and yet to make that an illusory right by having a circumstance where they could not be practically taken care of in what was the most important election that this state has perhaps ever seen. I think that the standard is exactly the standard that the Chief Justice has referred to, which is when will the date be such that passing that date endangers the ability of certifying and finalizing any contest that may result, so that the votes of Florida are not imperiled. And I believe that that's not an issue in this particular situation, because the counties have said that if you'll tell us what the standard is and leave us free from interference, we can get this done in a matter of days. Now, Broward County stopped because they were told to stop. Then they started again after this court said they could start, and you know what happened? Republican official or Republican attorney subpoenaed the canvassing boards to a circuit court, and the counting had to stop.
Well, that's not part of this record.
No, but Your Honor, what is part of it? Well, I think the court can probably take judicial notice of what happens in a circuit court. But I think the thing that's important for the court to understand is that this is a process that if people will simply get out of the way and let it continue, can be done in a matter of days. This court could, if the court would just give the county canvassing boards.
Where in the record would we find that it could be completed in a matter of days?
Well, Your Honor, in the, I think it's Exhibit G to one of the, to the exhibit that was filed in the circuit court, Judge Lewis's court, that is now part of this record. You have the letters from the various counties, Broward, Dade, and Palm Beach. And I think that the Broward to say, we'll give you the standard to apply, we'll tell you to get it done in 7 days. If the court were able to do that, you would certainly have enough time after that to complete a contest. And I'm not urging in any way that this court do anything that will imperil Florida's electoral votes. What I am asking is that the court use its power to make sure that all of the votes of the voters in Florida that have been cast for those elections counted.
But would you agree that if the court lifted the injunction and allowed the certification to be made, that absolutely there wouldn't be any imperil as to Florida's votes?
I would agree with that, except to the extent that if you did it in a way that permitted them then to declare the electors under 103.011, what you would have done is you would have electors that were not, in our view, the electors elected by the people.
Well, are those two different statutes then? Is that the only problem, is 103.011? Or is it the certification under 102.111?
I think that if the court were to make clear that the certification under 103.011, the declaration of the electors, was stayed pending the result of any contest, and were to make clear that the manual recount continues and will be considered, I think under those circumstances, having whatever certification is required under 102.111 to permit the contest period to begin would not prejudice anyone. We believe that that period can already be taken advantage of. That is, we believe that because 102.111 refers to both results and official results, and official results is defined elsewhere to include manually recounted votes as well as the initial returns. They could, and the contest statute does not depend on the official results being certified, but only results being certified. I think our view is that under the current statutory scheme, they can, or anyone can, file a contest with respect to the votes that have been certified. Obviously, you're entirely correct that even with respect to the recounted votes, those have to be done within a time period that allows a contest of those votes. But because those are a relatively small number of votes, that is a period of time that we are well within. So that I think one solution that would prejudice no one would be to provide that a party could file a contest with respect to the votes that have already been certified, that is, the non-manually recounted votes, right now, because they're not the official results, but they have been certified, and to provide that the manual recount would be completed within 7 days of the court's order defining what the standard is.
Mr. Boyce, I think your time is up.
Thank you very much, Your Honor.
The court is very appreciative and indebted to counsel for each side who has worked so hard and long on the presentations here and on what has been presented to this court for the court's benefit in attempting to arrive at a fair and just solution in this case. We also are very appreciative to our guests who have been here in the courtroom for the argument today. I make one final request of you, and that is that we now recede from the courtroom on the basis that all counsel be permitted to exit the courtroom and the building, and so that all post-argument interviews will be conducted not in the rotunda here, but outside the building, and then our visitors will be asked to, for security purposes, to exit the building after all counsel have exited the building. Thank you, and the court will be in recess.
The Chief Justice, who before it started today called all of this vital in importance to our nation, our state, and our world. Indeed, it is for the millions watching this live across the country today. It was nothing less than a lesson in law, certainly the law of the state of Florida. The stakes could not be higher. As was pointed out time and time again, the presidency has come down to the state of Florida. And watching along with us, a retired justice of the Florida Supreme Court, a former Chief Justice, Gerald Cogan. Judge, what